Hi, welcome back. Attorney Steve Vondran, the real estate lawyer, and we are talking in this video about Arizona eminent domain defenses, affirmative defenses, A.R.S. 12-1115, 1115. Don't mess that up because you end up with a totally different code section if you go to 115. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, so let's back on out. We're at the real estate whiteboard today, actually. And we are talking about A.R.S. 12-1115, 1115. This is what we call the least public, let's try that again. The greatest public good, least private injury statute. So let's call it the greatest public good. We're going to balance that. There's our balance against the least private injury. Okay, so that's what we're going to be balancing here in Arizona eminent domain. Okay, when the condemning authority, the Arizona Department of Transportation, SRP, APS, the city, a state, a town, county, if they're coming to condemn and they're going to do what's called a partial taking. Partial taking, this means they are not taking the whole piece of property. They're taking a strip or a piece. Maybe it's cut this way. Maybe it's cut this way. Maybe it's slanted. Okay, so you never know which way it's going to be. But if there's a partial taking, you're going to have just compensation for the piece that's taken, and you're going to get compensated for the severance damages, the damages to this remaining parcel, minus any special benefits that the city or the condemning authority can show that has been conferred on the remaining piece. But this video talks about affirmative defenses, things you can raise to say, wait a second, what's going on here? You can't just take down the middle of my property when you could just take it right here. Why are you doing it here and splitting my property in half when you could just take it right down here on the side of the road? So you're not calculating in my least private injury and balancing that against the greatest public good. Now, the city may say, well, you know, or the condemning authority, well, it has to go right here. It just has to, because our engineers said it does, and that's just our answer. The property owner can raise this affirmative defense of A.R.S. 12-115, raise it as often and early as possible in your answers, in demurrers, in OIP, order for immediate possession hearings. Raise the defense. If you don't raise it, my good students, you do what? Correct. You waive it. Raise it or waive it, folks. That's how it works. So you got ARS, you got this. In such a defense, in raising this defense, and it's on the burden is on the property owner to raise this defense, you need clear and convincing evidence. Clear and convincing evidence that the taking was not located, taking this balancing test into mind, it was not located in the proper spot. So you have the burden to come out and show that. So, for example, in this case, say they're taking a piece of property for a park, and they say, well, I want to put a park and a bike route. Excuse me. I want to put a park and a bike route and these kinds of things down here, or make some sort of drainage system here. That's fine, but can it be done here? Can it be done here? So this becomes the fight. This isn't an affirmative defense that you can raise in an Arizona eminent domain action. And if you need more information, you want to talk about this, you say, I really need to understand my rights, I really need to know if this is a good and fair defense in my case, give us a call, 877-276-5084. You can also find out more information on our website, arizonaeminentdomain.com, and we can help you, walk you through these issues, and help you fight for your just compensation and fight for your real property rights in the state of Arizona. Okay, Attorney Steve Vondran, the real estate lawyer, thank you for your time, and I hope this has been helpful.